Just a little bit about me. Again, I'm Michael Liptrot. I'm here at Tully Rinckey, Senior Counsel in the New York City office. I haven't been doing this forever, but feels like a long time for the past 10 years, focusing on family law and matrimonial. I've also done, some bankruptcy, landlord tenant, um, estate matters, but the focus has been family matrimonial. It's been an interesting experience for the past 10 years across New York City, the boroughs, and New Jersey. All right. It's just a little overview about what we're going to be doing today. We're just going to do a brief refresher on custody, how custody is determined, initial custody determinations, what the court's going to be looking at when establishing a custody and visitation order. The primary factor that where parental alienation, the subject of this presentation, is going to come in is the willingness to foster a relationship with the other parent. We'll be looking at the clinical evolution. That's actually not here, but this is an edit. Important to talk about the clinical evolution of the concept of parental alienation, when it started, where it started, how it started, clinical response, how it's evolved, and then we'll move on to how the courts have come to define the term. We'll look at some recent case law interpreting parental alienation, as well as some related issues. And we'll wrap it up there with some practice tips, what you might do if you have, the custodial parent where a child might be over a line versus, the non-custodial parent who's feeling some rejection and maybe is talking in your ear about parental alienation, something that can readily be found online. I've personally seen, been shown, presented to me numerous YouTube videos about so-called experts in the area of custody, telling non-custodial parents what their rights are and what parental alienation is and how you can spot it in your case. And they want you as the attorney to make it known to the court that you found that smoking gun with this two-word term, parental alienation. And then, we'll take some questions if we have time, and we'll conclude from there. So let's move forward. Custody determinations generally, we're going to take you back in time here, 1925 case. Long ago, the New York Court of Appeals, through Judge Benjamin Cardozo, embraced the concept that courts, in determining custody, stand in the position of parens patria, right? Latin term there. Drawing heavily on English law, and stated, the Chancellor, in exercising his jurisdiction upon petition, does not proceed upon the theory that the petitioner, whether father or mother, has a cause of action against the other, or indeed against anyone. The Chancellor acts as parens patria to do what is best for the interest of the child. He or she, not he, she at the time, is to put himself in the position of a wise, affectionate, and careful parent, and make provision for the child accordingly. He may act at the intervention or on the motion of a kinsman, if so, the petition comes before him, but equally he may act at the instance of anyone else. He is not adjudicating a controversy between adversary parties to compose their private differences. He is not determining rights as between a parent and child, or as between a parent and another. He interferes for the protection of infants, qua infants, by virtue of the prerogative which belongs to the crown as parens patria. Finlay v. Finlay, 1925. So those wise words have, formed the bedrock of custody determinations through to today. The best interest of the child standard that is articulated above is the central component in existing statutory hallmarks in custody determination, and remains the driving force of the present-day custody practice. That's codified in the statute, Domestic Relations Law, Section 240. See the quote there. Domestic Relations Law 240 confers custody jurisdiction upon the matrimonial court and Supreme and Family Courts of New York, and require that in determining custody in any action or proceeding brought to annul a marriage for separation, divorce, a writ of habeas corpus, or petition order shall cause the custody of a right to visitation with any child of a marriage, the court shall enter orders for custody and support as in the court's discretion justice requires, having regard to the circumstances of the case and the respective parties and to the best interest of the child. The best interest of the child is something that family law practitioners hear very often. The best interest of the child is the ultimate test. Here we have our 1969, one of our seminal cases, Lincoln v. Lincoln. The New York Court of Appeals in Lincoln v. Lincoln established that in a custody proceeding arising out of a dispute between divorced parents, the first concern of the court is and must be the welfare and interests of the children. Their interests are paramount. The rights of the parents must, in the case of conflict, yield to that superior demand. Always, always, always focusing on the best interests of the children. How do we determine best interests of the children? When evaluating the best interests of children for custody determination, the court considers a variety of factors. These are found throughout case law. Relative fitness of each parent, quality of the home, need for stability, parents' financial status, parents' ability to provide for the child's emotional intellectual development, and willingness of each parent to foster a relationship with the other parent. That factor, there are several other factors, but the willingness of each parent to foster a relationship with the other parent is the focus of today.
We're actually going to go ahead and read the first course code. So if everybody is ready to take that down, the first course code is going to be 749672. Again, the first course code is going to be 749672. Mike, you should be able to move on.
All right, I'm going to give everyone a moment there to get their course codes, critically important, and we'll move on. Okay, willingness to foster a relationship with the other parent. Courts have embraced the concept that it is generally in the child's best interest to have a healthy relationship with both parents following a marital dissolution. Go figure. Therefore, in determining custody disputes, the court may properly consider, quote, the effect that an award of custody to one parent might have on the child's relationship with the other parent. That is Bliss, Ock v. Ock, 1982. Any divorcing or separating parents feel great animosity towards one another for all of the suspected reasons. However, the court takes a dim view on the litigant who allows such animosity to spill over onto the child against the other parent. And that is a quote. That last bullet is not quoted, but that is a Lincoln v. Lincoln quote. Okay, so here we have willingness to foster a relationship with the other parent. We get to parental alienation, right? Parental alienation is the opposite of fostering a relationship with the other parent. That is in situations where there's a complete breakdown in the relationship between the child and one parent, the non-custodial parent, right? The one who's trying to exercise access. So we have here in 1985, Richard Gardner coining the phrase, quote, parental alienation syndrome, or PAS. Gardner's position or theory was that if we have a child who is refusing visitation and a parent who is supporting that refusal, then we have parental alienation syndrome operating. This thinking was black and white with a single cause, the supporting parent, and a single effect, the child refusing visitation with the other parent. Gardner's prescription for parental alienation syndrome was equally stark. Gardner suggested that in all cases of severe parental alienation, the only way to address it would be to institute an immediate change in custody. Gardner asserted that parental alienation syndrome could be reversed in 100% of cases of severe parental alienation syndrome if custody were to immediately change. So I'm going to dig in a little bit here about Mr. Gardner. Gardner was born in the Bronx. He goes on to graduate from Columbia University and complete residence in adult and child psychiatry at the New York Psychiatric Institute. So he became a child psychiatrist. Gardner, in 1985, coining parental alienation syndrome, he characterized it as a syndrome, which was and remains controversial. Notably, parental alienation syndrome has not been recognized by the American Psychiatric Association or any other medical or professional association. Accordingly, the term parental alienation has been fraught with controversy from its coinage by Mr. Gardner, and its initial entry into the legal arena was met with opposition and claims of bunk science. However, for better or worse, the term has survived its challengers, perhaps due to litigants finding the term online and thinking it fits their case, or attorneys who think that turn of phrase is creative or interesting or worth presenting to the court. And the term, in surviving through the years, has evolved. It's moved away from Gardner's assertion of it being a syndrome, and it's become more of a nuanced concept. And part of your course materials is an article from Dr. Philip Shaw, and it's 2003, but it really shows the arc of the evolution of the term parental alienation. This article serves as a pretty comprehensive primer on the evolution of the term and its relationship to high conflict custody cases. In it, Shaw redefines parental alienation as a child's unreasonable rejection of one parent due to the influence of the other parent, combined with the child's own contributions. Shaw rejects Gardner's, quote, linear model, where blame for the child's rejection of one parent is necessarily caused by the bad behavior of the parent who supports the child's rejection. The multiple causes of alienation that Shaw cites to may include the following: the personality of the aligned parent, and that parent's negative beliefs and behaviors that reinforce the child's aligned response; the personality and responses of the rejected parent; the level of conflict within a divorce action or the intensity of the proceedings, perhaps family court proceedings, if not a divorce; and the child's level of involvement in same, whether that involvement is, due to an attorney for the child being appointed or a forensic evaluation having to be conducted and the child is, appropriately necessarily being involved, or inappropriate involvement, one or both parents talking in the child's ear about the pending proceedings. Other factors include input from third-party professionals, relatives, or other third parties who may support the child's rejection of one parent or the over-alignment of the child with the other parent. Shaw also talks about the behavior of a alienated child's siblings. Older siblings who are alienated could cause the younger siblings to follow suit. A younger sibling who otherwise might not experience alienation or become alienated this could be a factor, and it may be no fault of one or the other parent. An interesting point, Shaw cites that the child's age is, quote, critically important, a critically important factor where older children are much more likely to display signs of parental alienation than younger children. Shaw also discusses that younger children are just more easily able to be forced to do things by their parents. They're told to do something and they do it because their parents say so. That becomes less, I think, any parent, maybe even of young kids or older kids know how that works. In the article, Shaw points out an important difference between estrangement and alienation, where estrangement is the refusal of contact after a period of significant problems with the parent-child relationship, right? Cases of domestic violence. Um, alienation is different than estrangement. Estrangement is almost appropriate. I think even Shaw in the article says that it would be an appropriate response for a child to reject their parent, where there's a history there, maybe of domestic violence or other significant problems in the relationship. Alienation is present in you have a child's sudden, unexpected rejection, an inappropriate response to an otherwise healthy and positive relationship in prior years. This is also, a clear evolution from Gardner's theory or definition, where it was just, if you find a child who's rejecting a parent and you have another parent who's supporting that rejection, then equals parental alienation syndrome, right? In addition to the evolution of the definition of the term parental alienation, dropping the syndrome, changing the definition, uh, listing these multiple factors, the clinical recommendations for what to do about alienation has also changed. An immediate change in custody prescribed by Dr. Gardner is now seen as a risky move, as opposed to being the sole prescription to reverse alienation. It could create more problems, obviously, than it will solve. And it has certainly been challenged that in 100% of cases, a change of custody will reverse the parental alienation. Current recommendations include requiring parents to undergo parental education, parenting classes, or other training, educational programming for the child, having the parties shift to a roughly equal parenting time schedule, implementing the services of a parenting coordinator to help parents work through difficult communications or where there's open questions about how to handle a situation, have a professional get involved on a case-by-case basis, as well as therapy for the individual parents or family therapy. In this article that I include in the materials, Shaw even goes as far as recommending that the parent who is experiencing rejection hold off on all visitation for a period of time, if the case is appropriate, and allow sort of a cooling off period before attempting to rekindle the relationship with the child. This is obviously at odds with the prescription here to shift to an equal schedule, right? So they're saying two things. But these recommendations are child-centered and fact-specific and are intended to address a spectrum of severity of parental alienation, where parental alienation is relatively minor, simply educating the parents about how to talk to the child and talk with one another could be enough. Where it's more severe, there might need to be more severe remedies, therapies, treatments. In every case, Shaw recommends that the parties, parents, the family, first participates in an evaluation with an appropriate mental health professional so that there may be an understanding of the particular family history and dynamics in order to decide on the most appropriate measures to be taken. Okay, so that was the clinical definitions, evolution, and that's obviously not what's been adopted necessarily by the court. The courts have obviously had to deal with parental alienation, I think, for a long time, rejecting alienation as a concept, as bunk science, largely dismissing it. But I have seen over the years that just maybe the persistence of the term has caused courts to really take a look at what it is and how it applies in custody cases. And we have here a good case, JFEDF in the New York Supreme Court, 2018, Supreme Court, Monroe County. They engaged in a comprehensive analysis of the concept of parental alienation. And they provide a handy definition here. Parental alienation as a legal concept requires that the alleged alienating conduct, without any other legitimate justification, be directed by the favored parent, with the intention of damaging the reputation of the other parent in the children's eyes, or which disregards a substantial possibility of causing such, which approximately causes a diminished interest of the children in spending time with the non-favored parent, and, in fact, results in the children refusing to spend time with that parent. So this 1, 2, 3, 4 list, obviously it ends with an and. All of these have to be present in order for the court to, determine, conclude that parental alienation is present in the case. This is obviously just a definition. It does not, they don't go into it here, what to do about it, so we have here, to go on to the next case. Second Department 2021, Suko v. Suko. And the basic facts, the parties were married and had 2 children. Mother commenced an action for divorce. The parties agreed that the mother would have sole legal and physical custody of the children with parental access to the father. The stipulation also provided that if either party moved the residence of either child beyond 75 miles from the present residence, the parties had to, quote, confer and enter into fair and equitable revisions of the parental access portion of the stipulation. So what happens? They have this provision here, and mom wants to move to Texas. In March 2015, father moved for a temporary restraining order, enjoining the mother from relocating with the children out of New York State based on her plans to move to Texas. We see here, father moves for a temporary restraining order. We do not have here the mother filing, as she probably should have, a petition for permission to move. And I think that might be one reason why the Supreme Court grants the father's motion. And in December 2016, mother moves the children out of state, not to Texas, but to Georgia. Father has to file a motion to have the children to return to New York and modify the custody provisions to award him sole legal and physical custody, alleging that the mother moved the children without consulting him. He thought they were going to Texas too, so maybe there was no consult there legitimately, or informing him of where he was taking the kids. And the court again grants the father's motion. And the mother, of course, appeals. Goes to the second department, and the second department highlights that, quote, parental alienation of a child from the other parent, including willful interference with his or her parental access rights, is an act so inconsistent with the best interests of the children as to, per se, raise a strong probability that the offending party is unfit to act as a custodial parent. The mother initially claimed that she did inform the father, and he said, quote, "It was cool," but later acknowledged that she did not tell him that she moved to Georgia, nor did she provide an address of where they would be moving. The mother testified that she should be entitled to relocate with the kids because, quote, "This is a free country," and the father was, quote, "no good," and did not believe he should ever be able to see the children. In contrast, the father testified if he were awarded sole custody, he would ensure that they spent time with their mother. Nice guy. Court found that the mother acted to alienate the children from the father, and he was more willing than the mother to maintain contact between the children and the other parent. Court affirmed that the father should have sole physical and legal custody of both children. So this case is interesting because they throw the term parental alienation in there, um, sort of as a throwaway. They don't go into any definition of parental alienation. It doesn't seem that they're using the clinical definitions here, um, but there's some strong case law being created here that parental alienation, whatever the second department is determining that to be, per se raises a strong probability that the offending party is unfit to act as a custodial parent. Per se. And they throw parental alienation probably appropriately under this willful interference of parental rights factor, but they don't go into too much depth about why they use this term here. That a relocation with the children is that parental alienation. That doesn't seem to fit with any sort of definition that we've been coming up with here. But I think that they, in looking at the transcript here, could see that the mother was, actively trying to maybe literally alienate the children, segregating them, separating them. But there is certainly no discussion in this case about the children's preferences, right, which is a major component of parental alienation, at least clinically. If the children were forcibly removed from New York due to the mother's bad acts, and the children still wanted to maintain contact with their father, that's not really parental alienation. But nonetheless, Second Department decided to throw that term in there and create this little bit of case law here of a per se lack of fitness. Okay, and we're going to go back to the Second Department again here. Khan v. Potdar. Basic facts. Parties were married and had a son. The parties separated and both petitioned for sole legal and physical custody. The lower court granted the mother's petition for sole legal and physical custody and awarded the father parental access. The father files an appeal and alleges parental alienation. Determining the appeal, the appellate court rejects the father's contention that the mother engaged in parental alienation. The father's basis there was that he did not see the child for 10 months after the mother left the marital home, but he did not present much other evidence of parental alienation. In fact, in response, the mother, to overcome this allegation of parental alienation, um, she satisfactorily proved that she had offered the father time with the child and he ignored her. Or if he did respond, it was to say he could not exercise the time. The record further demonstrated that the mother was more involved and knowledgeable of the child's special needs particularly with educational and medical services, more involved and knowledgeable than the father. And accordingly, the court affirmed the original custody determination. So again, there's no discussion here by the second department about what sort of definition they're utilizing for parental alienation, what factors are necessary for parental alienation, and also, perhaps any idea of what they might do if they did find parental alienation. They simply say that it's not here. And the factors that they use in rejecting the contention are the good acts of the one parent. So it seems at least that the second department, in looking at parental alienation, is going to be largely focusing on the acts of the custodial parent in fostering access, rather than even the child's stated preferences, which is maybe the opposite or reverse of how you should be thinking about it. Okay, so this is maybe a little parallel to parental alienation, allegations of abuse here, where this is more willingness to foster a relationship or the bad acts of the parents. Not quite parental alienation, but Courtright v. Boer Singh, Second Department, 2016. The basic facts: the parties were never married, but they had one child together. The family court awarded custody to the mother and visitation to the father. The father repeatedly tried to petition for sole custody, and the family court granted the father's petition. The holding was while the child was at the time, the child being 7 years old at the time the order of custody was issued, he lived with his mother since birth. Evidence was presented at trial that established the mother made repeated and unfounded allegations of sexual abuse against the father. As a result, the child and I'm sure the entire family was subjected to numerous examinations by medical professionals, law enforcement, and ACS, and other mental health personnel. The court determined that these examinations, being sort of chronic over time, had a detrimental impact on the child. The court found that these acts of interference with the parent-child relationship were so inconsistent with the best interest of the child as to raise a strong probability that the mother is unfit to act as a custodial parent. So here, Second Department, again, not quite saying that this was an act of parental alienation, not saying it out loud, and not at this time. This is 2016, so they go on to 2020 to get a little more forthright in their determination, but they do not address the per se lack of fitness of the parent, but these acts of interference are so inconsistent with the best interests of the child that they raise a strong probability that the mother is unfit to act. And the court affirmed the lower court's award of custody to the father on that basis. So again, this could be looking at the bad acts of the parents, a lack of willingness to foster the relationship, or active efforts to undermine a relationship. Not quite parental alienation under the clinical definition, where you have a child rejecting the non-custodial parent. We didn't. We don't know, actually. They don't go into that in this case, about the child's preferences, but nonetheless, I guess if you had the child also rejecting the father, then you could have a case for parental alienation. But here, the court's prescription was to confirm the award of custody to the father. Okay, moving on. We're going to throw another case at you here. Third department. Parties are never married, but they did have one child together. They agree to joint legal custody, primary physical to the father, and weekend visitation to the mother. And on one such weekend, the mother unilaterally refuses to return the child to the father and contends that the paternal grandfather was inappropriately touching the child on the father's watch. After a 5-day fact-finding hearing, the family court modified the custody order, granting the father sole legal custody and provided the mother with 2 hours of supervised parenting time twice a week. The mother appealed. So here you have real severe reaction to the mother's unilateral decision to withhold the child from the primary parent, and an allegation here of child abuse. And on appeal, the appellate court found that the lower court determined sufficient proof that the mother had coached the child to make false accusations in an attempt to alienate the child from the father. So this is sort of attempted parental alienation, and the appellate court affirmed the modified order of custody with that significant reduction in parenting time of the mother based on this. It's a single act. It's a real sharp decision in response to her real lack of judgment on this occasion. So yeah, it seems the third department seeing attempted alienation, trying to nip that in the bud, and it's an interesting case where you have the non-custodial parent being the perpetrator of parental alienation. You don't see that too often because usually you have the custodial parent, and the allegations are that the child spending so much time with the custodial parents that they're whispering in the child's ear, and their language is being mimicked by the child, and the child's adopting maybe the negative viewpoints of the custodial parent to say this or that about the parent with rights of visitation or parenting time. Okay, and here we're gonna have a lower court case, Bronx County, 2017. Interesting case where a forensic evaluation was performed looking at, among other things, parental alienation. So in the matter of CSVAL, Bronx County 2017, the facts here, petitioner mother and respondent father have 3 children together. The parties are in the process of separating. 2 children with the mother, 1 with the father. Shortly after, the father moves out with the one child. One of the other children alleged that the father sexually abused her, causing an abuse petition to be filed. As a result of the abuse petition being filed, the family court judge orders a remand of the child who was living with the father and removed her from his home, and issues a temporary order of protection against the father. The matter bounces due to the various petitions, bounces between various judges, referees, and eventually the first department before coming back down here to Bronx County. The mother withdraws her application for a hearing, and eventually ACS withdraws its abuse petition against the respondent. Initially, the child living with the father had mostly positive visits with the mother, showing love and mutual affection. However, out of the blue, quote unquote, out of the blue, the child begins showing hesitation to the visit. And then she starts stating that she no longer wants to visit with the mother and she feels uncomfortable in her presence. Go figure. The father would bring the child very early for the visits with the mother, creating a lengthy waiting period. Made her uneasy and apprehensive about the visit. So they'd sit, I guess, in the car, curbside, and the child would eventually, start demanding that the visit be canceled and to go back to dad's house. As time passed, the child became adamant about not visiting the mother. This child also started to refuse to talk on the phone with her mom, so eventually all of the contact between mother and daughter ceased. And the Bronx Family Court, in having to determine the issues here, initially determines the court addressed whether a forensic evaluation is required to determine if the child's refusal to visit with the petitioner is a result of estrangement, perhaps due to this estrangement, Dr. Shaw's definition, maybe even where the negative parent-child relationship caused maybe by all of this activity with ACS and the allegations of abuse of the other child, and eventually the daughter who was living with dad, ostensibly wanted to live with dad, and then was forcibly removed from his care, goes to live with mom, and then in the wake of that, simply wants no contact with the mother and is estranged? Or is it parental alienation? You have some factors here. Perhaps the father is intentionally making the child, wait in the car until the visit starts to get her geared up and feeling anxious, and then wanting to cancel the whole visit. This goes up on appeal, the court's decision to conduct a forensic evaluation, and the determination of whether to direct a social or psychological evaluation, sorry, it's going to go to appeal. The Bronx Family Court is making its determination here. Is within the sound discretion of the court, and the court knows that to determine what's in the child's best interest, the court must have adequate information to review the facts and circumstances in order to render its sound decision. Court cannot compel a parent in a custody proceeding to undergo therapy or analysis. However, it can order a parent or child to be examined by a psychiatrist or psychologist and consider the report in a custody determination. You can't force them to go to therapy necessarily, but you can require that a forensic evaluation be done. The court may not be able to, the court holds, the court may not be able to discover potential negative behavior by the alleged alienating parent without the aid of a professional, and a forensic evaluation is especially valuable in situations like this particular case. Oh, sorry, skip ahead here. And in support of the forensic evaluation, the mother cites Dr. Shaw's article, clinical forensic psychologist, wherein he describes the symptoms of parental alienation that include near complete rejection of one parent in favor of the other, superficial or trumped up, exaggerated complaints about the rejected parent with little or no substance, or inconsistent or contradictory statements and behaviors. Court says when ordering a forensic evaluation, the court must always balance the concerns about emotional cost to the child with the benefit of an independent professional forensic evaluation. And the court found that the subject child was exhibiting behaviors similar to those described in Dr. Shaw's article, which formed a sufficient justification for the forensic evaluation. So we have here the court looking at, this evolved definition of parental alienation and seeing that it's sufficient to get a professional involved. It can form the basis for a request for a forensic evaluation to be performed, at least to get the full scope of the dynamics of the relationship and the history of parenting, and perhaps discover whether parental alienation actually exists. That's what the forensic evaluation is for, just to see if it's there, not necessarily what to do about it. Although a report probably includes a conclusion about who would be the more fit parent, and we do have the second department case indicating a per se lack of fitness if parental alienation is present. Still not much by way of prescription as to how to ultimately deal with parental alienation if it's found. Although it does seem that the second department seems willing to maybe go along the lines of Dr. Gardner's original extreme proposal, that is to immediately change custody where parental alienation is found. Just a couple of maybe tips here to recognize the signs of parental alienation. We did talk about some of them up in the Bronx County case. This rejection of one parent, obviously that's the hallmark of parental alienation. However, this complete rejection may start out as small rejections. Eventually it can grow from using words, speaking negatively about the other parent. He's mean. I don't like being around him. I don't feel comfortable. But it can evolve if it is parental alienation. And it's unchecked. It can become absolute refusal to visit, and that's when you're going to run into a big problem as far as in a court case about what to do about it. Another sign of parental alienation is fusion of thinking between the child and the aligned parent. They use terms like us or we. The child loses their I, self, and is just overly aligned with that custodial parent. And they are involved, interested, overly so, with the proceedings. And just like in that Bronx County case, if you are representing the parent who is feeling rejected, really your best bet to establish parental alienation is going to be to get a forensic evaluation. It would be hard to make the case for parental alienation, as it is a it has its roots in clinical evaluation. We do have that Monroe County definition there, legal definition, but to make the case to the court to have sufficient evidence of parental alienation, you are probably going to want a mental health professional, psychologist, psychiatrist, with a forensic report. Okay, and in order to, if you're on both sides of the coin here, if you're representing either parent, you're going to encourage that client to encourage the child to stick to the schedule as much as possible, even if the child's being reluctant. Obviously, we have case law here, parental alienation or not. The courts are looking at the efforts of the custodial parent to foster that relationship. So if a child is rejecting the non-custodial parent, to make active efforts to encourage the relationship. If you keep a log of the concerning behaviors and occurrences with the child. It's going to serve as, contemporaneous memorialization of what's been going on and the evolution of the behavior, and also, probably what you did about it. Definitely do not share with children what's going on in your cases. Um, that happens all too often, and it is a recipe for reprimand from the court, and you may end up with an unfavorable opinion there. Um, don't become an alienator. Obviously, if you're in a contentious proceeding, you're separating from your spouse or partner, you harbor negative feelings. Children are highly intuitive little creatures, and they're going to pick up on it. So do your best to not use language in front of the children that is going to plant seeds in their mind about having a negative opinion about the other parent. If that sufficiently comes to the court's attention, it's going to be a big problem for that client. All right, so I guess that's all I have, and we're going to open it up for discussion here. I'm going to take a look and see as far as questions. We'll have Taylor here send me if there are any questions. We can have a discussion.
And please send any questions that you do have in the chat so I can send them over to Michael.
All right, we have a question here about grandparents. Would parental alienation syndrome exist involving a grandparent and grandchild with the sudden rejection of a grandparent by a child, whereas before they had a very good relationship? So I think that would be parental alienation. It could apply in that situation. However, a grandparent, they have a long road to hoe, so to speak, as far as establishing visitation. Um, if you are a grandparent experiencing that, you should get into court as quickly as possible, because grandparent visitation is a two-step analysis. It's an additional hurdle where you have to establish for the court that you had a fairly significant. I'm not sure what just happened. You have a fairly significant relationship with the child, an ongoing, close, robust relationship. And if you cannot show, and that relationship has to exist, obviously there can be animosity in the lead up to and during the pending proceedings. The court factors that in. But if you let things go, and there's a period of time where you've lost touch with the child, you may not get past step one. Step two is then the best interest of the child. And I do believe that's when, you might make the case for parental alienation being a factor in advocating for visitation. But I don't think that, I don't believe a court would change custody over to a grandparent where even if they found, alienation to be present, I wouldn't see that happening. Okay, so then another question is, could DSS be accused of parental alienation? That's an interesting concept, but um, from what I've read and seen, parental alienation is really more of, it's between the parents. I think you could stretch it to include the grandparents, as the person asking the question above maybe suggested. But to accuse DSS of parental alienation would not probably get you very far, um, because it's really parental alienation is looking at the dynamics of the family and the interpersonal relationships with parent 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 and child, and the rejected parent and the child. All right, I think that's all the time we have for questions. Thank you for participating, and I'm gonna click over here so that you all can get this code. All right, so there's code number 2 for you. Make sure you take it down so that you can get your CLE credit. It was nice to have everyone here. I saw some of you, and thank you for participating. You're all a lovely audience. Thank you for the questions, and have a great day.
I'm just going to read aloud the last course code for everybody. So that's going to be 347152. Again, the course code is going to be 347152. Thank you everyone again for joining today's presentation, and thank you, Michael, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you.